I'm very sorry and apologies that I cannot be with you exactly on the day of the conference. While it's probably not obvious from the background you can see, I am actually now in Palau Wilson, Geneva, at a session of one of the UN committees. And much as I would love to be in Budapest at the very same time, it proved not possible. But I thank the organizers, first of all, for the invitation to that conference, for the invitation to be one of the authors of the course book, and also for agreeing on this proposal and allowing me to prepare a very short pre-recorded presentation containing my chapter. So having said that, let me tell you about what I have been involved in terms of the authorship of the chapter. I will have a couple of points to make, and of course, again, it's a pity I won't have the opportunity to interact, but I just hope that we will have this possibility sooner or later. And also we can obviously exchange emails, for instance, on any subject that might be worth to consult on. So my chapter is on international dispute settlement. And I have been trying to show the existing methods that international law offers in terms of international dispute settlement. But one preliminary remark I would like to make is that I was wondering whether you might also have the same attitude or approach, that obviously we were trying to focus geographically on a particular region, just according to our editors and organizers' indications. But nevertheless, the very idea of international dispute settlement is, of course, a global one, and it's not only an idea, it's a rule. So the point of departure of my chapter was a global one, and then I proceeded to show some local illustrations. And by local, I mean specific disputes in Central Eastern Europe as defined by the editors of the chapter. So in essence, my chapter was aiming to show methods and institutions which were designed to solve international disputes, and also, well, taking, of course, the Central European perspective. The second part of the chapter is focused on international arrangements, also with particular reference to some selected disputes. As I mentioned, my point of departure was a global one, or universal one, if you wish, since I found it useful to recall that the principle of peaceful settlement of disputes is deeply rooted in the United Nations Charter. And, well, actually, it predates the Charter. It was also mentioned in the 1899 Hague Peace Conference, and it was also firmly, so to say, reiterated after the UN Charter, for instance, in the 1970 United Nations General Resolution on principles of international law concerning friendly relations and cooperation among states. So even if it is obvious, sometimes you need to start from the obvious, that in the UN era, international disputes are supposed to be settled, and I quote, in such a manner that international peace and security and justice are not endangered, end of quote. And that's a direct quotation from Article 2, Paragraph 3 of the UN Charter. Well, it's actually not easy to say so well these days, as we also experience and observe the horrible war in Ukraine. But still, the prevention of war and other threats to peace and security constitutes a very basic of international law. It's a vital concern. So these efforts on providing the methods to resolve disputes peacefully are understandably extremely significant in the if we take into account what the UN is for, or how the international community was organized and shaped in the second half of the 20th century. So obviously, my primary point of reference here is UN Charter, and also more specifically, Chapter 6 of the UN Charter, peaceful, actually the Charter says pacific settlement of disputes. And let me just refer briefly to, I would say, the milestone of the methods of international dispute settlement. I think it's important to note that already in the UN Charter, we have the rule that the parties to the Charter and parties to any dispute, the continuance of which is likely to endanger the maintenance of international peace or security, shall first of all seek a solution. And now, by negotiations, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of their choice. Well, so as we can see, the catalogue is quite broad, and it is up to the states to choose the right and preferred and agreed method of resolution of a dispute. So the catalogue is also opened. This allows the interested states much room for maneuver, because there might be many factors involved. Well, for instance, there might be political factors, the political will. There might be the willingness to engage a third party, because when we look at it, it would be the desired result if the parties would be able to reach an agreement just between themselves. But more often than not, this proves difficult, and a third party is consulted or is involved. Anyway, so this was my point of departure, but also moving on, my chapter also recalls what an international dispute is. And here, as probably we would agree that the reference should be made to the case law of the International Court of Justice, and so I also did, since traditionally we refer to the Mavromatis Palestine concessions case by the Permanent Court of International Justice, a case of 1924, and to the subsequent case law that clarifies when and what is understood by an international dispute, right? We need to know, as lawyers, we need to be precise in identifying an international dispute. So I would skip perhaps this chapter, because it's just about informing and providing you with some general scheme here. But nevertheless, I find it important to also say that there are some divisions, or we can classify, we can divide international disputes along a couple of criteria. Well, one of them is distinguishing between political and legal disputes. This has been also done historically. However, there are some controversies around it. It's not that easy to say that we can clearly and very precisely distinguish what's when we have a political dispute and when there is a legal one. Sometimes, of course, you've got a complex situation where both legal and political factors are involved. Now, further, there has been this distinction between justiciable and non-justiciable disputes. And, well, again, the first category is about, a dispute that you have adequate and applicable law to rule on, and when it's non-justiciable, you would probably need to use other methods or criteria. But this distinction is also controversial, as one of the questions I was posing myself, but also I was trying to answer, was, do you really have any possible international conflicts nowadays that you have no legal rules for? We are living in the world of where international law has been much developed over the last 50, 60, 70 years. Even though you've got new norms coming in, all the time, it is debatable whether or not you can still have a dispute that you simply find no law to use. Anyhow, I will be moving forward because also I know I have time constraints. It's interesting. I mean, the topic is interesting, as your topics are as well. But also, I would not like to, abuse the time discipline I was given. So, next subchapter is about the classic methods of peaceful resolution of disputes. And by classic, I mean these methods that were mentioned in the quoted Article 33 of the United Nations Charter. Let me recall, it starts from negotiations, and then it follows to inquiry, mediation, conciliation, arbitration, judicial settlement, etc. It's not like there is a specific order of precedence between the methods of peaceful settlement of disputes. You don't have, let's say, better or worse methods. When the method works, it means that it was rightly chosen. Anyway, what I would like to do in my chapter is then to briefly, what I've done is to present these classic methods and peaceful resolution of disputes, while also commenting on how and when they could have appeared and how could they be used in international practice, specifically in, let's call it, our part of Europe. By our part, I understand the Central and Eastern part. Since, that will be probably at an educated guess that negotiations are the most widespread and the most obvious and common method that come to mind. The states negotiate, well, all the time, actually. And this is a method that is a sort of natural in that case. But of course, it may happen that sometimes it proves impossible to reach a consensus just in bilateral negotiations, and a third party needs to be involved, a facilitator or conciliator. And what I discovered is maybe the word, but more what I believe is that we did not have much experience with conciliation as such in our part of the Europe, even though some successful conciliation proceedings could be mentioned and could be also shown as a possible example. Perhaps there is more to say about arbitration as a method of settling international disputes. This is more widely recognized and more widely used than conciliation. And that I will also comment on. But also when it comes to, the judicial methods of dispute settlement, I was trying to pick up certain recognizable examples which would, so to say, shed some light on the specificity, sometimes the regional specificity. And maybe you agree or not that one of the most recognizable cases concerning Central Europe at the International Court of Justice is the Gabčíkovo-Nagemáres project case. So this is one of my principal illustrations when I will be discussing the specificity of dispute settlement in a judicial way. I would probably not have time to discuss in detail the proceedings in Gabčíkovo-Nagemáres, but I think you know that it's actually the case which is still pending, surprisingly, after being brought in 1993, and after the court delivered, in fact, two judgments. I think that Slovakia and Hungary agreed to discontinue it around 2017. That I need a little bit more time to complete my small research about it. But this is a case which is interesting not only because it concerns the Central Europe, it also concerns some transformation or transformative process after 1989, with very interesting, so to say, disagreement, a dispute on the dam project. But I would say that it's also important because this is where the court, the International Court of Justice, in the Slovakian-Hungarian dispute, where the court specifically recalled and stressed the importance of negotiations in good faith. And let me just quote one paragraph, and one only, that the ICJ finds that Hungary and Slovakia must negotiate in good faith in the light of the prevailing situation and must take all necessary measures to ensure the achievement of the objectives of the Treaty of 16 September 1977 in accordance with such modalities as they may agree upon. So I believe that this is a very interesting illustration which specifically fits the premises, the framework of the course book. Now I will have other illustrations as well, although I will not be able probably to discuss them in detail due to time constraints. However, you might also know that there has been a dispute at the European Court of Human Rights, because part of my chapter will also deal with the regional arrangements, without, of course, discussing in every great detail, because we have our word limits. But I find it very important to say that there was this decision of the Grand Chamber of the European Court of Human Rights in Slovenia against Croatia case, which I think dealt with some regulatory schemes concerning pensions. This is a 2020 Grand Chamber decision, so also because it is relevant geographically speaking and it relates to international dispute settlement, it will be used. There is another case that I will mention where we have this interesting situation where the court's judgments then results in amicable solution, and that's very recent. In fact, you might have heard that there has been an ongoing dispute against Poland and Czechia concerning the Turów coal mine. It's a coal mine which is very close to the Czech-Polish border. And the case where we had also the judgment of the Court of Justice of the European Union in case C-121/21, Czechia versus Poland. So the judicial proceedings were initiated and they were continuing, but all in all, it seems that the situation has been at least tentatively resolved. Again, without going into much details, I think that this also shows that sometimes there are these disputes that find their way to the European courts, both the European Courts of Justice in this Polish-Czech dispute and the European Court of Human Rights if the matter cannot be solved differently. So in essence, I would also try to provide some feedback and some more detailed information and comments concerning other methods which exist but are not exactly frequently used. I haven't mentioned when I was discussing, I was just moving along and mentioning arbitration that, for instance, there are some mechanisms that remain unused, like the arbitration framework established under Organization for Security and Cooperation in Europe, which also is at the state's disposal to arbitrate, to provide some services, I would say, in that regard. But states so far, to the best of my knowledge, have not decided to use this particular method of arbitration. Dear colleagues, I was, so to say, asked and or obliged to talk for 20 minutes, which has already passed. But let me just sum up that I find this area of international dispute settlement extremely important, not only because, well, we all know that if it's not peaceful, then we turn to other methods of international dispute settlement, which we want to avoid at all costs. In other words, you know, I think you probably know what I'm trying to say now, that we are witnessing over the last 6 or 7 weeks what happens if peaceful settlement of dispute fails. Then we have atrocities and horrific reality of war that is so close to our part of Europe. And that's one of the reasons why perhaps these are the questions that would also be asked and in my chapter somewhere at the end. And I would like to use it as a sort to say the final words of my presentation today. More specifically, did the whole scheme of international dispute resolution fail? Because 70 plus years after, more or less 70 years after the new world order established under the UN chapter, after decades of avoiding war, and of course this was not always successful, after all that time and efforts, it proved impossible to avoid war, despite having so numerous methods of international dispute resolution. I am frustrated by that, I must say, that the aggressor state entered, attacked territorial sovereignty, and etc., and the catalogue of crimes, the catalogue of violations of international law is just becoming longer and longer every day. However, well, this is extremely saddening. Whether or not it means that international law failed as such is another story, isn't it? Because nobody wants to quash criminal code because crimes are committed every day, also domestically. However, and I would like to leave you with that question, that's something of concern for every international lawyer, isn't it? Both in, maybe even specifically in Central and Eastern Europe, since we are so close to this armed conflict. So there's this question like, are we able to think of a new system, some new methods or new solutions in this architecture of dispute settlement? While now it's still an ongoing war and conflict, it's perhaps not easy to focus on some future solutions, but sooner or later we will get there. In other words, there will be again the discussion on how to improve this international legal order, and including how to improve the international dispute settlement to avoid situations such as happening now in Ukraine. Dear colleagues, apologies if I have a little bit extended the time limits. Again, I wish you very fruitful discussions. I wish I could be there. But anyway, I am looking forward to the next steps of this course book project, and I do hope we will have the opportunity to meet in person. Thank you so much, and I hope to see you. Bye.